Welcome to the seminar, We Are Family, Surrogacy and Adoption for LGBTQ plus parents. This is part of Coram's month-long Pride celebrations. And really, these talks are aimed at intended parents, so laypersons versus solicitors. But I do know there are a lot of solicitors joining us today, so there will be information that you might find useful as well. You'll be hearing today first from myself on surrogacy, and then from Kieran Pugh, who's also a member of Coram Chambers, and he'll be speaking to you about adoption. And then finally, we're really lucky to have Richard Westerby, who is on the board of P3 and is also a father via surrogacy himself. And so he'll let you know a little bit what's going on the ground at the moment. If you have any questions, you're welcome to put them in the chat function, and then we'll aim to answer some of them by the end, time permitting, of course. So if I just start us off with surrogacy. So surrogacy and the law, what you need to know as an intended parent if you're from the LGBTQ plus community. So starting off with the basics, the legality of surrogacy. So there is some confusion about what is and is not allowed. So in the UK, surrogacy arrangements are legal, provided that they're altruistic. So in theory, no money is supposed to change hands. Now, commercial surrogacy is prohibited, but if you, as an intended parent or as a surrogate, engage in a surrogacy agreement, then you're not guilty of an offense if payment is provided that is beyond reasonable expenses. So we have this funny situation where we don't really have commercial surrogacy, or we're not supposed to, but we actually do in practice. What is illegal, however, is advertising that you're looking for a surrogate or that you're willing to act as a surrogate. There are some exceptions in that under the realm of nonprofit organizations, but you can't, for example, put out an advert in a magazine or anything like that. Likewise, it's illegal to broker a surrogacy arrangement, again, with some exceptions like nonprofit organizations that assist in arranging surrogacy partnerships. But for example, if you are a solicitor, you can't set up an agreement or a contract, or you shouldn't be, between a surrogate and an intended parent, because that can be seen as brokering an agreement, which is very much illegal. And the other thing to know about surrogacy contracts, whilst we're on the topic, is that they're unenforceable, even if you, in this jurisdiction, even if you have one, whether it's from the UK or from abroad, you can't force the surrogate to hand over the child once the child has come into this world. That being said, they can be helpful, surrogate agreements, to know what the expectations are of the intended parents and of the surrogates. So things like discussions around what kind of diet the surrogate might be having, whether she's going to smoke while she's pregnant or abstaining from smoking. It's a good thing to set out as much information as possible. And a lot of the nonprofit organizations, such as Surrogacy UK, for example, have templates that you can utilize to make this easy. Now, finding a surrogate can be a really difficult matter, especially if you're looking within this jurisdiction. So because it's an altruistic jurisdiction and we don't have a regulatory framework in the same way as somewhere like, for example, California does, then there are very limited ways in order to find a surrogate. So what we see are a lot of people asking friends or relatives, utilizing some of the nonprofit organizations. So that's what I mentioned before. There's four main ones. There's COTS, there's Surrogacy UK, there's Brilliant Beginnings, and then the new kid on the block is My Surrogacy Journey, which does sort of a mix of international and domestic surrogacies and is really putting itself out there as a different formulation of the, as opposed to the nonprofit organizations. It's a different way of doing things. Other ways that people find surrogates are social media and apps. Again, you'll have noted I said earlier that you're not supposed to advertise. There are, however, lots of closed Facebook groups, but I would really advise people to approach those with a bit of caution. There are reported cases of stories where surrogacy arrangements have gone wrong, where people have found surrogates via Facebook groups and entered into agreements without really knowing the other person. and in some occasions has ended up very badly with protracted proceedings in the High Court. So that's something to be very much aware of, because when you do it within the realm, for example, of one of these nonprofit organizations, you do have a framework and you do have a lot of support put in place that you don't have by virtue of going, on a less well-traveled route. Of course, one can also find surrogates abroad, and there are in lots of jurisdictions, there's very robust and very healthy services set up to assist you in that. But there are a lot of considerations to be taken into account when you're deciding whether to go home or abroad. So in terms of surrogacy in the UK, and to make the decision to do it here, the pros are, obviously you're not going to have any travel or immigration issues. It's easier to keep track of your surrogate if that's what you want. Some people very much want to have a relationship with their surrogate. It's easier in many ways to get the evidence you need for the court later on because the person is local. The application is made in the family court, so it doesn't have to go to the High Court unless there's some complicating issues. And there's possibly less chance of exploitation of the surrogate, though again, it's not unknown. And one of the cases with a closed Facebook group is a case around exploitation of the surrogate in this jurisdiction. And the cost, for example, in this jurisdiction can be cheaper than going somewhere, for example, like California, where it's going to be much more expensive. Now, one of the major cons of trying to find a surrogate in this jurisdiction is the lack of available surrogates. Because we don't have a commercial surrogacy business, essentially, there seems to be less surrogates around, and you can't identify a surrogate, or it can be difficult because advertising surrogacy is illegal. So, for example, I referred earlier to some of the nonprofit organizations like Surrogacy UK or COTS, and they tend to have quite long waiting lists to even get into their nonprofit organization stream before you're even meeting surrogates to try and form a relationship. Cost, whilst it can be a pro, can also be a con in this jurisdiction. So there's an average amount in this jurisdiction that's sort of between, I'd say, 15 and 20,000 pounds. But you can also go places abroad which might be cheaper than that. And I think, for example, of places like Georgia and the Ukraine can sometimes be cheaper than surrogacy in the UK. On the other hand, there's pros and cons of surrogacy abroad. So it's sort of the flip side of the pros and cons of surrogacy in the UK. So of course, there's going to be a greater pool of surrogates because you have the world at your fingertips. You can go to countries where it can be a streamlined process. And again, you'll hear me referring again and again to California because they are very much have it down to a T. It's very regularized, and lots of people engage in it, and it's just a well-run machine. Cost, as I said before, can be a pro because you can go to countries where it is cheaper than doing it here. The cons, of course, are one big con is immigration. Now, it can be difficult depending on the circumstances and depending on the country that you do your surrogacy arrangement in to bring the child back into this jurisdiction. And I would highly advise anyone who is engaged in a foreign surrogacy or even thinking about it to seek specialist immigration advice. And that's not only immigration advice in the country in which you're arranging the surrogacy, but also in the UK as well. One thing to be very alive to, and I'm sure people have seen the news around this, is that surrogacy laws can change quite rapidly, and that there's the risk of children being stranded. For example, we saw the laws change quite quickly in India, followed by Nepal, and there were a lot of talk in the media about couples whose children were essentially stuck there until they could make their way there. The other thing to think about in terms of international surrogacy is homophobia and transphobia. So the places where you can, as an LGBTQ plus person, engage in surrogacy are more limited than for heterosexual couples. There are places also that are completely unregulated, which means that you can engage in surrogacy there, but the context within your doing it is a homophobic or transphobic society. So, for example, Kenya is somewhere that I've known same-sex couples to go to engage in surrogacy, but at the same time, I'll use homosexuality because that's the term they use in their laws, is outlawed there. And so it can be very uncomfortable. And you have to think about the fact that as a couple or as a single gay person or single lesbian, you are going to have to stay in that society for a while. And so you have to ask yourself whether you're comfortable being there whilst you wait for all the administrative issues to be sorted out with your child. A foreign surrogacy arrangement goes directly into the High Court. That can accrue greater costs, and the more complications there are, the greater the costs are going to be. It's potentially more difficult to get information if your surrogacy is abroad. Of course, again, that depends on what country. Places in America tend to be fine. Places abroad in Eastern Europe can be more difficult. The cost of going abroad for surrogacy can be incredibly expensive. And there can be some concerns about exploitation depending on where you are. So it's something really to think about before you decide on your surrogacy journey is what's going to be in the best interests of yourself and your partner if you have one, and what's going to be workable around your lives as you go in this journey to find a baby, to have a baby. But the most important thing to note, and the one thing I would want you to take away from this talk today, is that regardless of where you do the surrogacy arrangement, so whether it's in the UK or abroad, the intending parent or parents must apply for a parental order. Now, this is quite a difficult concept for lay clients to get their minds around, because a lot of the time you'll go into a jurisdiction where you and your partner are listed on the birth certificate. And so that seems, a fait accompli. Well, why, if I'm listed on the birth certificate, do I need to then come back to this jurisdiction and have my parenthood recognized yet again when it's already there in black and white? Now, the reason for this is that we have a very specific set of definitions in this jurisdiction around what constitutes a mother, a father, a second parent, and those remain in place regardless of where you did the surrogacy arrangement. So the parental order really extinguishes the legal parenthood and parental responsibility of the surrogate and of the surrogate's husband or wife or civil partner if she's in any one of those relationships. And it provides the intended parent or parents with legal parenthood and parental responsibility. Because until such time as the parental order is made, you are not recognized as the child's parent, except in certain situations, which we will go into now. So looking at in this jurisdiction, what we define as the legal parents. So the legal mother of a surrogate child is always the surrogate mother, regardless of whether she's genetically related to the child or not. And this is what we call an irrebuttable presumption. You can't get away from that. So whoever you're using as your surrogate is going to be the legal parent of your child. If the surrogate mother is married or civilly partnered at the time of her treatment, then her husband or wife or civil partner will be the legal second parent. So again, that is regardless of whether they're genetically related to the child or not. I mean, it's more likely than not that they're not going to be. The only exception to this is if they didn't consent to the treatment. So one can think of, for example, a surrogate who is married but is estranged from her wife. If it can be shown the wife didn't consent to the treatment, then the wife won't be treated as the second parent. But usually in most circumstances, the surrogate's husband, wife, or civil partner is involved in the process, has consented, and so the parental order is needed also to extinguish their legal parenthood. When the surrogate is unmarried and not in a civil partnership, you can actually still nominate the legal father or second parent. So if you don't nominate anyone, then the commissioning father will be regarded as the legal father of the child. So for example, if you're in a same-sex male relationship, then the man who supplied the sperm will be regarded as the biological father. However, you can also do it the other way around. If the surrogacy arrangement takes place at a licensed fertility clinic, then the surrogate mother can nominate or appoint the commissioning mother or the non-biological father as the second parent. So sometimes I've seen or had same-sex couples who one of them is providing the genetic material and they then decide together that they'd like the other one appointed the legal father. They've told me it's made them feel both of them are involved in the process. But again, it's very much a personal choice. Sperm and egg donors are not regarded as legal parents. A caveat with that is that sperm and egg donors are a legal category. So if your friend donates sperm and just gives it to you, it's not a sperm donor situation. Sperm donorship has to go through things like quarantine and testing and so on. So that's something just to be live to, because you may see the person as a donor, but the law might see them as actually a father. So hopefully what's become clear is that we have these definitions of what parents are. And so what you need to do as an intending parent is apply for a parental order, which then extinguishes the legal ties that the surrogate and her partner have to the child. And then you can have that child legally recognized as your own, which for all intents and purposes, the child is already psychologically, intentionally, and at least for one of you biologically. So the criteria for obtaining a parental order. Now, the child must have been carried by a woman who's not one of the applicants as a result of placing in her an embryo or sperm and eggs via an artificial insemination. So essentially what this means is that there has to be a surrogacy arrangement, which really goes without saying. Now, you must be 18 and the applicants must be married, civilly partnered, or two persons living as partners in an enduring family relationship, though more recently the law has changed so that single applicants can now apply. Two persons living as partners in an enduring family relationship is a funny one because enduring family relationship is not actually defined in the statute. And really, one could argue that if you're intending to raise a child with someone and be legal parents with them, then you are prima facie entering into an enduring family relationship. When the court's looking at that, they look at things like the relationship you have with the person. Are you living together? Do you have joint credit cards? That sort of thing. But there's no minimum or maximum time that you have to have been living together. And the court is happy to construe it in such a way that the welfare of the child is ultimately met. Now, one of you must have provided the genetic material for the child. So when you have a couple, then one of you must have. If you're a single applicant, then you have to have provided the genetic material for the child. This is something that is currently under review by the Law Commission, because one could argue that it is discriminatory, for example, against a single applicant who themselves is infertile. But at present, this is what the law unfortunately is. Now, the application itself must be made during the 6-month period after the child is born, but not during the first 6 weeks after the child's birth. And the reason for that is that the surrogate mother will need to give her consent to the parental order, and the threat of postnatal psychosis is the greatest in the first 6 weeks. So that explains the 6 weeks stipulation. When you make the application for a parental order, the child must be living with you and any other applicant. Most of the time, that really goes without saying. Sometimes we've had situations, though, where you've had the child abroad and you get stuck there, and maybe both you and your partner can't afford to stay there. One of you has work commitments, so you have to go back and forth. We've also had situations where people have applied for parental orders and then they've split. And the court has been very willing to construe the living with you and the applicant in a very broad sense. So living can mean having your house with both of you, but separately. What we see in the courts is very much they're willing to bend over backwards to make these orders, provided that's in the children's best interests. One of the applicants must also be domiciled in the United Kingdom, or if you're a single applicant, you must be domiciled here. Domiciled, again, is a very tricky concept for people to get their heads around, but just to put it in layman's terms, essentially you have to be looking at staying in this jurisdiction for the rest of your life. All of us are born with a domicile of origin. If you move somewhere, then that can become your domicile of choice. But whether that it becomes your domicile of choice is dependent on what your intentions are, essentially, and in some ways how much you're integrated into that community. It is different from habitual residence because it's about looking at permanency in the long term. And again, it's something that you have to provide evidence to the court if you're pleading a domicile of choice. But things like, mortgage payments, owning property, being naturalized, or getting citizenship in this jurisdiction, all of those assist in your application. Now, consent. Obviously, consent is incredibly important when you have a surrogacy arrangement, and both the surrogate mother and her husband, wife, or partner, if she has one, must freely and with full understanding of what is involved, agree unconditionally to the making of the order. And there's a specific form on which consent is given. One form has to be done by the surrogate and another by their partner, if applicable. And it's really sacrosanct. I mean, it doesn't matter if you have consent in a different format, if you've had a surrogacy agreement from another jurisdiction, the court needs to be satisfied that it's been filled out on the prescribed form and that the surrogate has consented. And that is one of the aspects of the parental order criteria that the court hasn't been willing to play around with. So things like the time limits, where the child is living, the court has been much more flexible with those, but with consent, they will not make a parental order unless consent has been given. Now, this brings us to money. Now, as I intimated earlier, we have a bit of a funny system where it's altruistic, but really in practice, money has changed hands. And this is really reflected in the parental order criteria as well. So in theory, you must not have paid any monies or benefit to the surrogate, but in practice, the court has the power to retroactively approve any payments or benefits. I should say that reasonable expenses are absolutely fine. Those don't need to be retroactively approved. But any other payments, including anything that can be possibly seen as remuneration, is going to need to be retroactively approved by the court. Now, in practice, this doesn't form a difficulty at all. The court really will approve it, provided that the amount is not an affront to public policy. But I haven't yet seen a case where they've said that a certain amount is an affront to public policy. And, we're looking at cases where surrogates have had remuneration in the sort of 50, 60, 70,000 pounds. And yet that still hasn't caused the court concern about retroactively approving those payments. What is important is that you do have a record of what payments were made and what they were used for. So that the court will want you to set out in detail which one were reasonable expenses, what those were utilized for, and which really they're going to have to be retroactively approving. But ultimately, as I said, all of these criteria are in theory supposed to adhere to. But when deciding the application, the welfare of the child is paramount. And so the court will be looking to and straining really to make these orders, because they know at the end of the day, it's almost always going to be in the best interest of the child for their intended parents to be recognized as their legal parents. It is what is happening on the ground. It is the reality of these children, and it really sets out what everyone has intended from the beginning. So it's very difficult to imagine a situation where the court would say, well, actually, the people who you are genetically related, at least one genetically related to, should not be recognized as your legal parents. So I've also listed some resources there. So Surrogacy UK, COT's Brilliant Beginnings, and My Surrogacy Journey, as I said, are the nonprofit organizations. My Surrogacy Journey, the Alternative Parenting Show, Families Through Surrogacy are also an incredibly helpful place to start. The government has produced incredibly good guidance on surrogacy. One that I haven't included here is there is a website which sets out the legality of surrogacy across the world, and where you can engage in surrogacy, but also ones that are LGBTQ plus friendly, because that's of course important to find out before you embark on any surrogacy arrangement. Now, that's very much a whirlwind tour through surrogacy. There's lots more to discuss, the process and so on, but we only have limited time. So I'm going to pass over now to Kieran, who is going to speak to you about adoption. Kieran, over to you, and I will stop sharing my screen so that you can add yours.
Thank you, Bianca. Yes, I'm Kieran Pugh. I'm also a barrister at Coram, and thank you everyone for dialing in. I'm going to talk to you now about adoption, and if you just allow me one moment, I will share my screen, in theory. There we go. Bianca, can you see that?
I can, yes.
Thank you. All right, so yes. When I started thinking about how to approach the issue of adoption from an LGBTQ perspective, it seemed to me that really there are two main sources that create anxiety. The first is the adoption process itself, which can at first glance look utterly bewildering. There are so many stages, there are so many variations, there are lots of terms which will mean something to professionals, but not necessarily mean anything to those trying to enter the process. Equally, from an LGBT perspective, we're essentially approaching a process which has historically been very heteronormative. It's been dominated by heterosexual couples seeking to adopt. Very likely it's been dominated by heterosexual professionals assessing, applying those kinds of considerations. It can be very concerning to LGBT couples who can foresee themselves going up against an institution, perhaps being the little guy, and also engaging in a process which is really subjective. What we know about subjectivity is other people can start to import their own value systems. I'm here to tell you two things. One, the process, as bewildering as it can look on the face of it, can be navigated, and I'm going to show you how to do it. And two, from an LGBT perspective, if anything, I'm seeing a trend towards LGBT couples. I'm seeing a real positivity coming from organisations and individuals working within those organisations alike. So I'm going to start first of all with what is adoption? Okay, so you're probably coming to this process because you know what adoption is in principle or in theory, but just to be clear about what that really is. So it's a legal procedure whereby parental responsibility in relation to a child is transferred from their birth parent, and it's then vested in the adopter. What that means is that the legal relationship between the child and their birth parents comes to an end. And once the adoption order is made, the legal relationship between the adopter and the child is such that it is as though they are a full member, or rather they are a full member, and it is as though they have always been a full member of their new family. That, as you can imagine, has wide-ranging consequences, but what it really means is you are creating a new family at the point that you make that adoption order. You'll see what I've included at the end here is that it's a significant legal order. It really is. They are not usually reversible. The circumstances in which they can be disrupted are incredibly limited. I think I have only come across one in recent years, one case where an adoption order was subsequently overturned, and that was where everybody concerned, including the child themselves, who was now an adult, felt that it was the right thing to do. But the circumstances in that case were really quite unique. From our perspective, adoption is final. Just focusing then on what is meant by parental responsibility, and I appreciate this is going to be a little bit technical for those who are not lawyers, and perhaps a bit basic for those who are, but let's just be clear. When we're talking about parental responsibility, we're talking about all the rights, duties, powers, responsibilities and authority by which a parent of a child has in relation to the child and his property. Basically, everything that you as a parent can do under the law, and the things which make you recognised as the parent transfer from the birth family to you as the prospective adopters. I just want to focus then really quickly a little bit on why LGBT adoption is important. Let's start with just where we are in terms of LGBT representation within society as a whole. You can see here that this is really the distribution. It's 2.7 of the UK population identifying as lesbian, gay or bisexual. That's increasing. Both for men and women. But what I really wanted to focus on just for a moment, and I've added in a couple of lines here. If I look at the age range of people who are, I suspect, most likely to be considering adoption, so we take it from mid-20s up to late 40s, just taking a very broad brushstrokes approach to statistics. I'm not a mathematician. I'm doing the best I can with the basic skills I got at GCSE, but there it is. I think really what we're looking at is roughly about 20% of the population within that key adoptive age range identifying as LGB. What that translates into in terms of numbers coming at it from the other angle is coming up to the end of the year, 31st of March 2020. I'm afraid those are the most up-to-date statistics available. There were effectively 570 children adopted by same-sex couples. That amounts to about 17%. So broadly speaking, coming up to about the 1 in 5, 1 in 6. So more or less on trend. And I just want to take a slightly closer look at that. 170 male married same-sex couples, 120 female married same-sex couples, 70 male civil partnerships, 30 female civil partnerships, and then 120 male couples who were not married or civil partnered, and 60 female couples not married or civil partnered. Now, you might have noticed a sneaky little star down there at the bottom, and that's because, and it's a source of frustration for me, when I went through the statistics, it was really quite disappointing that the Office of National Statistics don't really deal with the representation of bisexual adopters and trans adopters. So essentially, if you are in a relationship which can be identified as one of the previous categories, albeit that might not necessarily how you self-identify, then you'll be counted. If not, then you don't. There's nothing I can do about that, I'm afraid. I am bound by the statistics, but it is a source of some frustration that it means that we're not really necessarily getting an accurate picture. That said, let's look at the good news. Until 2005, gay couples couldn't adopt. There were some reports of organisations getting around it by identifying one member of a gay or lesbian or bisexual couple who would essentially be assessed as a single adopter, albeit that they were recognised as being in a relationship, but not recognising couples together. There was obviously a change in the law at that time. Back when LGBT Adoption Week started, you can see that there were 1 in 22 adoptions by LGBT couples. That has very obviously, therefore, risen steadily year on year. And as I said before, with my very basic math skills, we're very quickly coming into line with something which is much more proportionate in terms of national statistics in terms of LGBT recognition. Hopefully, if I've dispelled concerns about whether or not you are treading a path which has not been trodden before, you're going to be wondering, how do I even get started? Well, the process I thought was very well set out on this website, and I'm going to be able to share this with you towards the end. But let me say, First for Adoption. First for Adoption is a website that was established as part of that drive, first identified back around 2005. It is a national website backed by the government, and it's really there to try and collate all the information you might need into one place so that you can try and navigate the adoption system with ease. So this is really a complicated process distilled into 4 stages. And as I say, believe me, that this really is very much distilled into a simple process. I'm not going to take you through all of it in detail. It seems to me there's little point in me simply setting out here what you can read for yourself on the website. And I must say, as somebody who's been through the process, has had many clients go through the process, it is very well set out, and it is clear, and it's not written in jargon. So do take your time to look through that. Getting started. In terms of getting started, it really is as simple as going to Google. That may seem ridiculous, but there it is. That's because most local authorities are adoption agencies themselves. So if you are contemplating adopting, a very good place to start is to type in your local authorities council website with the word adoption, and you will very likely land on a page which is designed for people in your area considering adoption. If that doesn't work, then as you can see here on First for Adoption, on just about every single page, they are urging you to click this button that I've highlighted, which will take you through a process of identifying what area you're in and then what is the agency which serves your area. They really are trying to make it as easy as possible for you to get started. So stage 1. I just want to insert at the beginning here, before you get to stage 1, you are very likely to be invited to an introductory evening. The introductory evening is unlikely to be led by your agency necessarily. That is because a number of agencies often club together. For example, there is the North London Consortium, which is a group of local authorities in North London. I think there's also a South London Consortium. And really the reason they do that is to share resources. There's little point in 8 local authorities all running introductory evenings when they can share the burden. What I would say about introductory evenings is they can be a little bit hit or miss. I'm aware of one which was incredibly excitable. There was lots of positivity. There was a real sense of celebration about the people who had come there. I have been told about another attended by a client where, frankly, the person running it just looked like they wanted a cup of tea and a sit down. So it really can be hit or miss. What I would say is this. It's an introductory evening. It's just there to talk about the basics. And it's really just a case of trying to establish whether or not this is for you, and then really pointing you in the right direction if you haven't got there already. Stage 1 then of your assessment is the registration of interest. This is a legal requirement. It's basically it's a declaration that you want to be assessed as an adopter and that you are asking a particular agency to do this. You'll see what I've said here which is ask your questions now. And what I mean by ask your questions now is ask your questions of the agency, what you want to know. For example, I know of one client who was particularly keen to know from a particular local authority whether or not they had ever assessed a gay couple before. he was delighted because they practically fell off their chair saying, absolutely, we love it when gay couples come forward. And I will share this information with you. There is very good reason for local authorities to be very positive about gay and lesbian, bi and trans couples. And that is because, and this is a quote, it's because very often for people from LGBT backgrounds, this is your first choice. You have come together as a couple, you have reached a stage in your relationship where you want to adopt, that you have thought about it, and this is your first port of call. And so from their perspective, they are dealing with people who really are committed to the process and are not at the same time perhaps trying to work through other difficulties, such as having to effectively deal with loss that they may have experienced, and that's really why they are quite keen on working with LGBT couples. First stage questionnaire. Looking at the website, it would seem to suggest that it was a straightforward questionnaire, a little bit of background, a couple of referees. Do not be fooled. Set time aside to complete your questionnaire. I have just gone through a client's questionnaire with them. It now runs to 120 pages once completed. It's long. You're going to want to set time aside to do it. You're going to want to set time aside to think about it. It can involve videos that need to be watched, thought about, reflected upon. It takes time, so make sure you set time aside to do it. Preparation groups. These are similar to the introductory groups, but they are usually much smaller. They are much more a case of an all-day preparation group. You might get to meet an adopter who's been through the process, somebody you can ask questions of. Again, in relation to LGBT presence at these groups, a group that was recently run was not specifically LGBT, but was 80% LGBT, and that was purely by chance. It reflects the people who are coming forward. And so do not be afraid or worried that you're going to be in the minority. Far from it, you're quite likely to be in a majority. Once you've been through this process, stage one, there is an opportunity to pause. And you can take a pause of up to 6 months. Any pause that you take in the process does have to be explained in your final assessment. There are good reasons for pausing, there are bad reasons for pausing. But one thing that you might want to think about before starting this process, and certainly before you move on to stage 2, is whether or not there are any foreseeable life changes that might cause a disruption. For example, one client was asked to take a pause because they were due to get married between stage 1 and stage 2. And quite rightly, the social worker said, I cannot possibly take you through the intensive process of assessment and a home study, talking to you about what life might look like with a child when you're distracted with trying to organise a wedding and all that goes with it. So equally, for example, a change of employment. And that's not just a change. I am aware of one couple where it was a promotion, a long sought after and well-deserved promotion. But the view of the social worker was, you are going to be experiencing new challenges, and I don't want you focused on those new challenges whilst at the same time as trying to engage in this intensive piece of work. So there are good reasons for pausing, and don't perceive that as a negative thing if your social worker recommends it. Buy a folder. My goodness, this generates so much paperwork, it's unreal. And if you're in a position of trying to lay your hands on something at at short notice. Good to have it all in one place. Stage 2 of the process. So once you've gone through stage 1, you've moved past any period of pause, there's an assessment plan. You build that with your social worker. There's more groups, more preparation groups. This might move into the area of training, specific training about what to expect, how to deal with it, parenting skills, and really getting into the nitty-gritty of the experiences of some of the children that you might be asked to consider having placed with you for adoption. The home study, I've put it in bold. That's what I think most people will have in mind when they think about an adoption assessment. It's long periods of discussion. It's a lot of work around your own experiences growing up, how that might impact on your parenting. One of the reasons that form that was completed, that questionnaire that was completed in stage 1 is so lengthy, is so that when your home study starts, your social worker hits the ground running, already having a pretty good idea of who you are, your background, your social network, and all the support that you could be drawing upon, so that they can get under your skin sooner rather than later. There is no point in them wasting hours going through, well, in Uncle Joe on my mother's side 3 times removed, you know, none of that. You have to do all of that in Form 1. That's why it takes so long. And you'll probably find that yourself screaming at your laptop as you try to complete the genograms, because formatting is not your friend. Panel decision, that's what it all comes down to. So once your assessment is completed, your social worker will make a recommendation, and then you'll be taken to a panel of people who will consider your assessment and will consider whether or not to approve you as prospective adopters. It's a nerve-wracking day. Nobody pretends that it isn't. But the most important thing to remember is that social workers by this point have invested so much time and energy in you as a prospective adopter that they are highly unlikely to put you before the panel if they have any real concerns about your suitability. It is far more likely that they will have spotted that early on. They'll have talked to you about how to address it, and they'll work that through with you. These are very often very positive days, but you have to remember what it is that the panel are considering here. They are considering placing a child with you, a child who may well have had very difficult past experiences, and they're going to want to know that you're in it for the long haul. They're going to want to know that you're committed, and that they're going to want to know as best that they can that any child that's placed with you is going to work. So once you've got through stage 2, we then move on to the matching, and that's where we start to bring together you as prospective adopters with a child who is waiting and ready to be adopted. So let's just focus on these children, where they come from and what their backgrounds are. So there really are, I think, really 4 main routes into adoption. And the first and for most children, are children who have been identified as suitable for adoption by court. And we'll look at that in a little bit more detail in a moment. There is adopting a child who's been relinquished. I have to be clear that I think many people who go into adoption think that there are many children being relinquished on a regular basis. It's actually very rare. I am aware of only a very few over the last few years that I've come into contact with. There are private adoptions. I'm not going to focus on that today, not least of all because they're quite uncommon, and also adoption from abroad. Very difficult to explore that without knowing the country of origin. And more often than not, if you're looking to adopt from abroad, it's because it's a country with which you have some kind of a connection. So I'm going to focus on for the main part on children who have been identified as suitable for adoption by court. So that happens by way of care proceedings. So care proceedings are proceedings which are brought by local authorities, so social workers, and they are in relation to children in their area who they've identified as having suffered significant harm or are at risk of suffering significant harm. Care proceedings, they are supposed to be completed in 26 weeks. The system works really hard to achieve that. It really does. But it's more often than not honoured in the breach, I'm afraid. It is made all the more worse, as I'm sure you can imagine, with COVID. Proceedings are getting longer and longer. Children are waiting longer and longer for decisions. But the aim is to try and get that done within 26 weeks. Why does it take so long? Well, it takes so long because it is and of itself a process, not just an application. It's a process of investigation, if you like. So there are multiple hearings that take place over the course of that 6 months. The first one is really to determine what should happen to the child whilst all of these investigations are completed. Shortly after that hearing, we have what's called a case management hearing, and that's where we identify the assessments that are required. Following those assessments, we will come back to court and we try and work out, okay, well, which bits of this investigation are agreed and which bits are still in dispute. And ultimately, the court is asked to make a final decision. So as you can see, multiple stages, logical, but there are, as I'm sure you can imagine, twists and turns along the way, which I'm not going to trouble you with for the moment. Importantly, for your understanding of how these children are coming into the system and being deemed ready for adoption, the local authority, once it's received all of the assessments, has to prepare what's called a care plan. The care plan's a document which sets out why the local authority believes that adoption is the right plan for the child, if indeed that is its conclusion. Now, in care proceedings, children have their own representative, and that's called a children's guardian. Some of you may be familiar with CAFCAS. The guardian might agree, the guardian might disagree. But either way, if there is a live application for permission to place a child for adoption, the guardian's got to prepare a report, providing their own analysis as to why they agree or disagree. When the court is deciding what's the best outcome for a child, the child's welfare is its paramount concern. There is, however, an added layer when considering the question of adoption. And that is that the court's got to be satisfied that nothing else will do. It's got to be satisfied that it's necessary to dispense with the parent's consent to adoption, because this really is the only option which is going to satisfy the requirement that the child's welfare be paramount. Care proceedings can conclude with other outcomes. For example, we can have children at home under care orders, or they can remain in foster care. There's a whole range of options. But when the court is considering that an adoptive placement is right for a child, they make what's called a placement order. Don't be alarmed. I know it looks a bit much, but the reason I'm showing you this is because if you thought that that process sounded a little bit quick or rushed or flimsy, this is what a local authority has to do before it even makes its application to court. So you can see that there are multiple stages, there's lots of considerations, there's lots of attempts to try and make things work with a family, there's investigations, there's meetings, there's various levels of concern and how those are addressed. And the care proceedings that I was just talking about are way down here, right in the bottom right hand corner in that single box. So the reason I'm really showing you this is just so that you can see that by the time that a child has been made subject to a placement order, the court really has thought about it, and the local authority has really thought about it in incredible amount of detail, and a lot of effort has been made to make sure that that is the right plan for the child. And there it is. That's the conclusion that I've just set out. Importantly, that decision to free a child for adoption is made in isolation. It's made separate from any consideration about you as a prospective adopter. These two processes are happening in parallel. They're not happening in concert. So it's not the case that you have to be the best adopter and therefore that a placement order will be granted. They happen quite simultaneously. And they only come together at a point at which you have been approved and the child has already been made subject to a placement order. That's the first point at which we'll start to compare profiles and see whether or not this is a good match. Lots of reasons why you can come into care. Again, if I could really direct you to the website that I mentioned earlier, First for Adoption, there is a good summary of what each of these things could mean, how they might impact on a child, what that might mean in terms of future issues. But what I would like to emphasize is what I've put at the bottom here, is that cases are so rarely about a single issue. There are cases where they are, but very often it's a number of these factors overlapping, intertwining, which leads ultimately to a conclusion that nothing else will do. Right. Everyone's talking about trauma. If any of you have stepped through the doors of one of these meetings thus far, you will have heard this word trauma. It used to be that the buzzword or the word of the day was attachment. We seem to have moved on in recent years to the buzzword being trauma. Don't panic. Don't panic about this word trauma. What does it mean? What it simply means is that for you as a prospective adopter, it might be that there are certain behaviours for a child that's been placed with you that you don't understand. There are behaviours which from the outside might look like naughtiness or challenging behaviour or disruptive behaviour, but when you understand where it's coming from, why it's happening, you will understand better how to deal with it and how to address it. I am aware of a number of people who've walked away from this process because social workers were laying it on very thick about trauma, and prospective adopters walked away simply thinking, I can't handle this. I think that would be wrong. And what I would like to introduce you to perhaps is this. Trauma, just really quickly, effectively, it affects the way in which the child perceives the world around them. And the reason for that is because when we're born, brains are not fully formed. They are formed very much and very rapidly in the early years of life. So as I'm sure you can imagine, if you have a negative experience, that's going to affect your brain development. The important thing from your perspective is these things are very rarely set in stone. With attuned care, and you'll hear that word over and over again, attuned care, you can undo what has been done. And very often, of course, by the time that children are being placed in your care, they will have been in foster care for a period of time. Many foster carers, absolutely excellent, very well trained, very well supported, and the child that's transitioning into your care will have already had a good foundation in care which has been designed to try and repair any damage that has been done. I'd like to recommend this book. It's called What Every Parent Needs to Know by Margot Sunderland. It's the first couple of chapters explain about brain development and explain why the concept of trauma is not something to be panicked or worried about, and also that it's something which simply requires persistence, but also patience. So this is what it means for prospective adopters: understanding, training, and patience. Okay, so here's an example. A couple, an LGBT couple that I represented, really struggling because the child placed in their care would not go to bed, would not stay in bed, would come and sit on the stairs repeatedly throughout the course of the night, and they were exhausted to the point when they just couldn't do the taking up the stairs again, only for him to come back down. It transpired, once they explored it in a little bit more detail with the child social worker, that this was a case where child's mother had gone out in the night, drugs, alcohol and sex work, and so he was frequently waking up to find nobody there. You can imagine, once you understand that, and once you understand why it is that he's coming to the top of the stairs to check, what's required is patience and persistence, but mostly reassurance. And sure enough, working that process over and over again without frustration, and maintaining a calm persistence, the issue resolved itself over time. That is one example. The reality is that you may well find with a child's placed in your care who has had an experience, you might not know what it is, it might take some time to figure it out, but there will be advice to help you tailor your response to that. So if you hear the word trauma, there is absolutely no need to run a mile in the opposite direction. So, questions. These are questions which have been asked of me by people who felt embarrassed or worried to ask their social workers, because they were worried about what it might say about them as prospective adopters if they raised it as an issue. What if there's a history of parental mental health? Okay, bottom line is, if one birth parent has a mental health background, the broad brushstrokes are that there is about a 10% chance that the child you are looking after will also experience some kind of mental health difficulty, not necessarily the same. If both parents have had mental health difficulties, that statistically raises to about 40%. But it's not like for like. So you cannot assume that simply because there is a background, for example, of schizophrenia, that is necessarily what the child in your care will experience. But there is a connection, a biological connection in terms of parental mental health. Forewarned is forearmed. Make sure before you are considering a placement with a child that you have got a good understanding of not just their background, but in as much as you can get it, the background of the parents. What is the impact of drugs and alcohol in utero? Not good. Largely, the impact of those, and in many respects, alcohol is the more problematic. That largely, the impact is usually some degree of developmental delay for the child. What if I don't think I can handle parenting a child with a disability? Then don't. Quite simply put, this is not about trying to get your foot over the line so that you can adopt any child. The crucial element here is matching, finding a match between you and the child in question. So if you don't think that this is going to work for you, better to be open and honest about it, and explore that in more detail with your social worker. That's right there in stage one. What kind of child do we think we're going to be able to parent? What about ethnicity? Is it essential that we're a cultural match? No. Are we limiting our chances of having a child placed with us by preferring a cultural match? Potentially. But again, this is something where you really need to explore it with the social worker in the early stages of that process. There could be very good reason why a cultural or ethnic match is preferred. Equally, there could be very good reasons why it simply isn't an issue. For example, if you are in a position where you do consider you could parent a child with a disability, then it may well be the view of the child social worker that is so much more important to the child in question, than what is to be gained from a cultural match. These things are never set in stone. There's no hard or fast rule. There is always a constellation of considerations around a match. What about birth parents? Do we have to facilitate contact? The answer to that is, if there is no order in place, it's not, you're not forced to, but you will be asked to explore, as part of your assessment, views in relation to ongoing contact with a birth parent. What happens in the event of placement breakdown? Social workers are going to work very, very hard to avoid that. They're going to explore with you what further support can be offered. They're going to explore with you even potentially respite. That's where the child, for example, might go back to their foster carer for a period of time. There are always options before you even get to that point. Once a child is placed with this, can the birth parents take them back? There are applications that birth parents can make right up until the point that the adoption order is made, even after the child's being placed. But I have to say, in 15 years of doing this work, I have not come across a case where such an application has been successful. By and large, once a child has been placed with prospective adopters, the disruption and the negative impact on their welfare of trying to reverse that really renders that a non-starter. That's not the legal answer, but there it is. Of course, it doesn't matter what your finances are. Of course, the local authority are not going to want you to be stressed out by being in debt, but this is not a process where you've got to pay every inch of the way to try and adopt. In actuality, adoption agencies are not allowed to charge you for their services. There might be a charge, for example, for completion of your DBS or background check, but not the adoption process. Fostering to adopt, this is really a specialist area. It's emerging. It seems to me to be reasonably unregulated at the moment. If you're offered it, do consider it, but ask questions. The main question or the main point is there is no guarantee that the child placed with you as a foster carer with a view to you adopting will stay with you. The decision to release them for adoption has not yet been taken, so you're very much fostering on a speculative basis, albeit that the reason that this has happened is the professionals think it's unlikely that the birth parents will be able to turn it around in time to be able to resume caring for the child. So there we are. I've probably overrun hideously, but in conclusion, this is not a new thing. LGBT adoption is a path that's been well trodden in recent years. Our numbers are on the up. Initial access to the process is really easy. They're trying to make it easy. That's a good thing. And the process is intense, but it's worth it. And I think that's about it. So thank you. And if there are any questions, feel free to put them in the chat now.
Thanks, Kieran. Well, I think we're going to first hand over to Richard, who's going to tell us a little bit about what's going on the ground. And then if we have time, feel free to put questions at any point in the chat. And then if we have time, we'll get to them. But we'll see how we get on. Richard, over to you.
Well, thanks a lot for, first of all, having me. For those of you who don't know, P3, or Proud Professional Parents, is an organization that was started a few years ago by our CEO, Tuvia, who works in the city. I used to work in the city, I don't anymore. But basically there was a group of parents, LGBT and allies, who decided that, there wasn't a support network that was run by parents to help parents or prospective parents to understand what needed to be done. How could you do it? So for example, Tuvia went through adoption. I went through surrogacy in the States. We've got people that have been through surrogacy in the UK. And what we really do is we're here to in essence, help guide you and navigate the process of family building. But we also help organizations to understand the legal aspects of what can organizations do to help you as well, from an HR perspective, parental rights, all those different bits and pieces. But what's been obviously has for all of us, COVID, right? We haven't been able to do events. It's been very difficult to get face to face, meet people and mentor people through the process. So we've just been doing a lot of online and not as much we'd normally do. But so one of the things that Bianca was talking about earlier was surrogacy, right? And that's what I did. So I have 8.5-year-old twins, boy-girl twins, born in the US. And a lot of what has changed in this sphere is all about the LGBTQ space, right? So my husband and I went through the process in the US, where there's legal protection. You understand from the outset what's happening. So when we were looking at different jurisdictions, we did exactly that. We looked at the different countries. We're like, okay, where can we go? India was just about to fall over. We were warned against it because it was about to fall over. You know, you had Thailand, you had the US, you got Canada, the UK. And now that I know more about this process, because obviously I do it, I help people navigate it. The only countries where you have some form of legal protection, if you're LGBTQ and you want to have a family, the United States, Canada, and the UK, right? If you go to the Ukraine, you go to Georgia, you go to Mexico, you go to Colombia, Kenya, there's no legal protection. In fact, there was a big article out there, I don't know if any of you saw it, on surrogacy in the Ukraine. You have no protection, right? Do you want to go through this process and at the end of the day have nothing when your child is taken away from you because of X, Y, Z? Well, no, you don't. And so just really make sure that when you're looking at whatever you're looking at, you've spoken to the team here, right? You understand the legal framework, you understand what's available to you. Call me, I'll walk you through what's needed. Call Tuvia, if you want to go down the adoption route, right? He's lived it, right? He has a beautiful little boy, Harvey, and he's done it. It is a super long process. Both of these processes are very long. They're very involved. And at the end of the day, all that everybody wants is what is in the best interest of that child, right? And we as an organization, we just believe all a family needs is love, right? It doesn't matter to what Kieran was saying. It doesn't matter what your finances are. It doesn't matter what ethnicity you are. It doesn't matter where you live. If you're able to provide that child with that love, care, and attention, and believe me, it's a struggle sometimes. I have my son just on the other side of here, who's nodding at me going, yes, it is. But, you know, it is. And they push buttons and they do all these different things. But ultimately, at the end of the day, if you can give them a big old hug and just say, do you know what? I don't care what you do. I love you. That's huge, right? That unconditional love is something that is insane. And when you're going through this process, you get that feeling. So if you're wavering, you're worried about the finances, you're worried about the process, you're worried about all those things, and those are very valid concerns and worries, you are supported. We are all here to help you, right? We want to make sure you're doing it properly. Otherwise, you wouldn't be coming to a seminar by us. So where you can understand what the legal implications are, what the legal process is. But again, everybody's aiming to take that pressure away so that you can focus on doing what it is you want to do, which is creating that family. And literally it's the best thing you'll ever do. So top tip, do it.
Oh, that's lovely, Richard. Really brings the human to our law side of things. But no, I mean, I agree. You know, obviously I come from it from a legal perspective, but seeing the joy and being able to help people be able to achieve family formation. I mean, it's really the best part of my job, and mine's just the professional side. If you're doing it personally, then it's beyond words. It's wonderful. And you know, just for anyone who's interested, is that the academic studies around LGBTQ plus families are that children who are part of what we call alternative families tend to fare the same, if not better, than children of their heterosexual parent families counterparts. So there's been you know, quite a lot of studies done on this, so no one should ever be concerned that, again, like Kieran says, you're treading an unknown path. But you know, really, it's just at the end of the day about being able to have a child and love that child, whether that child comes to you through surrogacy or adoption or a turkey baster. So I don't know if I appreciate that it's already 6:48. People are probably wanting to run and go get a drink or dinner or something. If you have any questions, feel free to put them in the chat. If you don't feel that if you have questions, but you don't feel that you want to say them aloud in front of everyone or put them in front of everyone, then you're always welcome to contact myself or Kieran or Richard by ourselves, by email or whatnot. I see that Kieran has very helpfully put in the website of First for Adoption and the book. So if you'd like to ask a question, ask now. Otherwise, we will say goodnight to everyone. Well, that's a resounding silence. So hopefully just means we have been so brilliant. We have stunned you. Thank you, Alessio, for the thank you comment. Very much appreciated. And a happy Pride, everyone. It's a weird Pride because, we're not being able to do our normal things, but we're all celebrating in spirit and in the way we can. And hopefully we'll be able to do it. Oh, someone does have a question. If one person in a couple relationship isn't out to their entire family, would this be an issue for adoption? Kieran, what do you think?
Not necessarily. Where it could become a difficulty will be in relation to understanding what your family network looks like, what your support network looks like, what the risks might be to the child in question from having effectively a side of the family from whom presumably they wouldn't necessarily have a relationship. I suspect what would be expected is that over time you would come out to that side of the family, but then I don't know what the personal circumstances are. So it's a very difficult one to say. That there's not a hard and fast rule about that. If you have good reason not to be out, then I don't think you would be prevented from adopting. But yes, the social worker would want to explore that in some detail.
Wonderful. Well, if the surrogate is legally married but domestically separated, would permission still be need to ask for a parental order to be put in place? The answer to that is yes. If they are technically married, provided that the ex-partner, even though they're still married, consented to the fertility arrangement. So if it can be shown that he or she didn't consent, then they don't need to provide to the treatment, then they don't need to provide the consent form. But that's really then a matter for the court to decide whether the estranged husband or wife did consent to the treatment or not, which can also be kind of a difficult legal thing to navigate. So really erring on the side of caution, I'd get consent from both the surrogate mother and her husband, wife, or civil partner, even if they're estranged. If, for example, they're estranged to such a degree that they have no knowledge of the surrogate going through the process, then that could then be construed as they didn't consent to the treatment. So that's sort of a different issue. I know that's quite of a blurry answer, but it's very fact specific. Perfect. Thank you. Does anyone else have any questions? Lovely. All right, everyone. Thank you so much and have a wonderful evening. And thank you to Richard for joining Kieran and me this evening. Always a pleasure.